If it pleases the court, my name is Dixon, initial C, and I am appearing on behalf of the defendant, Mr. Johnny Wishbone. I am making this application through the Section 590 AA provision of the Criminal Code, based on the admissibility of evidence being presented by the prosecution, which it is at your discretion to exclude, as per Section 130 of the QEA. Before I begin my submission, I would like to remind Your Honour of the purpose of the Police Powers and Responsibilities Act, which is listed in Section 5, and particularly subsection E, which reads, "To ensure fairness and protect the rights of persons against whom police officers exercise powers under this Act." I base my application on these significant facts. My client is facing 106 charges of an indictable offence. My client is a juvenile and was at the time of his arrest a juvenile, and he is a Torres Strait Islander. My client was arrested and subsequently questioned at the scene of the arrest, after which he was driven by police car around the suburbs for a while until they got to the police station where a formal interview was conducted. But because of who my client is, the police had very strict procedures to follow. My first submission is as follows. The statements my client made following his arrest, and those made in the car on the way to the police station, were not recorded or written down, as is standard practice in Queensland policing. The PPRA section 436, subsection 2 reads, "Questioning must, if practicable, be recorded." Simple. There is nothing to suggest in any way that it would have been impracticable for the police to record the conversations between them and my client. Queensland cases such as the Crown and against Williams have made it abundantly clear that the PPRA provides a safeguard against the fabrication of evidence by the police. The truth of what was said that day lays in the hands of the police officers, and it casts doubt upon the transparency of their case. I will now lead on to my second submission, Your Honour. On the way to the police station, the police, who were dressed in plain clothes and driving an unmarked police vehicle, proceeded to take a bit of a detour on the way to the police station. Taking my client through the suburbs, they pointed out houses that they claimed had been burgled and posed questions to my client, such as, "Johnny, that house over there has been burgled. Did you do that?" Using this tactic, they managed to secure 106 charges against my client, without ever first having notified his parents or a guardian, and they did not caution him about his right to silence. And back at the police station, they conducted a formal interview. Again, they did not contact his parents, and they full well knew that he is a Torres Strait Islander and that he is a minor. Now, the law is very clear. If I may direct Your Honour to Section 421 of the PPRA, particularly subsection 2A. Before questioning starts, the police officer has, if practicable, allowed the child to speak to a support person chosen by the child in circumstances in which the conversation will not be overheard. The same provision also applies where questioning Torres Strait Islanders, and that is found in Section 420, subsection 4. No support person was present in the car ride. There was a support person present in the formal interview, but we don't know who that person was, and my client certainly did not choose that person to be his support person. It could have been anyone. Had my 16-year-old client been given adult guidance before and during the questioning, he could have been told the consequences of making admissions or about his right to silence. These points of law are also supported further by the PPR code, Section 25 directs police officers that they must, before questioning Aboriginal or Torres Strait Islanders, they must first ask questions to ascertain the person's level of education and understanding. This could have highlighted to them that my client needed some proper assistance in this case. So-called support person was telling my client to just make sure he answers all questions. Your Honour, my client was made to confess involuntarily. Complete disregard of his right to silence, and that is provided for under section 431 of the PPRA, and also in complete disregard of the purpose for which the PPRA was set up, as I have iterated before in section 5 subsection E, to ensure fairness to persons whom police officers exercise their powers against. The discretion Your Honour has in this case derives from the High Court case of Bunnings and Cross, the Ireland discretion. And having examined the admissibility of the improperly obtained evidence, common sense will dictate that to allow a jury to hear such evidence, it would mount to a severe miscarriage of justice and encourage unlawful, shoddy police practicing in the future. Thank you.